Good morning, everyone, and thank you for joining us. On behalf of our team at Pro Benefits, we welcome you and we thank you for not only your time today, but your continued partnership and work with our team. Greetings from our home office in Winston-Salem, also known as the home of the Wake Forest Demon Deacons. Unfortunately, there's no sports going on right now, but hopefully we'll see that before the end of this wild year. As some context for where we are today and the important benefits changes that we're going to discuss with you and cover with some legal updates and also some administrative updates. As a word of context and perspective, 2 months ago today, March the 13th, at least here in North Carolina, school was still in session. I think March the 16th was the first day that school was out. March the 13th, Friday in March, was basically the first day that sports and a lot of national activities and mass gatherings had been canceled. And without question, through this whole process, and the point doesn't need to be belabored, that health and safety of Americans, including you and your family and your colleagues, is paramount. But on March 13th, the same way we didn't know what would happen with the pandemic that had come to our country, we also had no idea what would happen in benefits, as many employers started the process of figuring out, how employees would be treated with employment status and benefits over the next couple of months. And the hot topics in those first few weeks related to eligibility, leaves of absence, termination of either coverage or benefits, furloughs, layoffs, and other employment situations. Those were the hot topics of the first couple of weeks. But beginning later in March, with several laws passed by Congress, we have seen over this short period of time the most significant benefits compliance changes that our business and this industry has seen in quite some time. The only comparable thing would be the Affordable Care Act, but the Affordable Care Act took effect in stages. The law was passed in 2010. Some things took effect in 2011, some in 2013, some in 2014, some in 2015, and so on. Whereas all of these changes have been made in a relatively tight 6-week period. So what we are going to do today is to not only share a word about the resources that we have available to help you as our clients, and our assistance for you can go beyond the specific line of service that you have with us. We're going to do our best to help you in any way that we can relating to various topics, but also address these legal developments in order, again, both what the new rule is and how we're adapting to that particular change to help you. As we launch into this, I want to say a brief word about our team. I think that you have some experience working with our team. We are very blessed to have some strong folks. Laura Bibb is our Senior Compliance Counsel. Laura is a graduate of UNC Asheville and also the University of North Carolina School of Law, so she is a Tar Heel, but we love her anyway. And Laura is just one of the best in the business, and she's been with Pro Benefits for 2 years, and we're very fortunate to have her, and she helps us cover a wide range of compliance needs. John Cobra was also a graduate of the University of North Carolina, Asheville, and also a graduate of Wake Forest School of Law's Master of Studies in Law program. John's done an excellent job for us in various roles over a number of years. I'm very fortunate to have been friends and colleagues with both of them for a long time. Starting next week, Chris McCauley, who some of you know, who was previously on staff as one of our benefits attorneys, Chris McCauley will be rejoining our team next week. So we're looking forward to having Chris again and continue to bolster our team. It's both a sign of strength, but also a sign of necessity in the current situation where we are. But Pro Benefits continues its commitment to compliance and assisting employers in any way possible. In terms of resources that we have, many of these we share regularly by email with you and through our web resources. We continue to build FAQs for key topics during the COVID-19 period and post those on probenefits.com. There are 2 separate categories, one for participants in FSAs, HRAs, HSAs, and Cobra. There's another section for employers and broker advisor partners. We've been doing a webinar each month, and if you need some additional training on, for example, leaves of absence or how to treat benefits elections during the leave of absence, we have some training materials in writing and via webinar for those topics. So any topic that you think today or after today may be helpful, we'll be happy to share with you. For participants, if you're not currently using our mobile app, please check that out. You know, even if you don't have a scanner, for example, at home, the mobile app allows you to take pictures of receipts and documentation to support eligible expenses and upload those as part of the claims process for FSA. As one example, Benefits is active on social media in various capacities as shown on the screen. And then most importantly, our team is available to assist you, and our various teams ranging from sales to technology are serving employers and participants each and every day. A quick overview of the guidance and legislation that has come out in the last 2 months, starting with the Families First Coronavirus Response Act, which we won't talk about today, but that was one of the changes that covered in one of the prior webinars relating to some extension of FMLA leave and also paid sick leave for certain categories of employees during this COVID-19 period. The CARES Act, the major act signed into law on March the 27th, that included not only the stimulus provisions for individuals, but also provisions and relief for businesses, including the very popular Paycheck Protection Program for small businesses was part of the CARES Act, along with another item or two that we will mention momentarily. Last week, actually announced 2 weeks ago and then published in the Federal Registry on May the 4th, a new DOL and IRS rule regarding deadlines and an extension of federally mandated deadlines that apply to benefit plans that we will cover. And also there have been 3 separate IRS notices impacting benefit plans that your company may sponsor, including 2 that were released yesterday morning. So even in preparation for this webinar, when we were already preparing to talk to you about changes with FSAs, changes with HSAs, changes with Cobra, yesterday morning these 2 IRS notices were released. So we've gotten up to speed on those in time to share with you the gist of what's important about those notices and some additional changes that may be coming, all designed by the federal government to assist participants. So some of these changes you may look at as very positive, some of them you may look at as a hassle, but know that they're all designed, at least the well-intentioned, to assist participants. So what we're going to do at this point is just start with these changes. There are actually 7 specific changes we need to let you know about. We're going to start, and Laura and John will cover each of these in rotation.
Thanks, Jason. Thanks for the look back over the history of kind of where we've been and where we've come. And the first change that we're going to talk about today is the over-the-counter drug repeal. And this was part of the CARES Act, which was passed March 27th of 2020, which now seems like a very long time ago, but not too long ago. This change repealed an ACA rule, a longstanding ACA rule in effect since 2011, and allowed over-the-counter drugs or medicines to be reimbursed tax-free, effective on or after January 1st of 2020 for health FSAs, HSAs, and HRAs. And specifically for HRAs, we're really referring to the 213D HRAs. Many folks were very excited about this change, especially during this time when participants maybe weren't able to have more of traditional expenses of going to the doctor or elective procedures. They were able to use their FSA, HSA, and HRA money to purchase these over-the-counter drugs. The list of over-the-counter drugs was to be updated by 4/15. It's our understanding that the debit cards are working for over-the-counter drugs, medicine purchases, but there may still be some slight inconsistency with merchants. But generally, it is our experience that the debit cards are now working for these expenses. We have already made system changes to accommodate the repeal of the requirement to have a prescription. So submission of these claims should be working and up to speed for everyone. And then again, the cards, again, we believe they're working. although there may be some inconsistencies if the merchants themselves haven't completed their update. Lastly, this change does require an update to plan SPDs for all health FSAs and for some HRAs, those 213D HRAs. And we are in the process of making those necessary updates, and we'll be sending out more information to you all very soon about those updated changes for the legal documents.
The second change that we want to thanks, Laura. The second change we want to address is the DOL notice that Jason mentioned earlier that came out last week, an extension of the claims and appeals deadline. This particular extension, as you'll notice there, applies specifically with regards to the FSA and certain HRA plans that we administer there. Typically, typically FSAs have a standard 90-day runout, and HRAs typically have anywhere between a 90 and a 180-day runout. This notice came out extending claims runout periods that ended after March 1st, 2020. And so this was an extension for, particularly for calendar year plans that ended in December of 2019 and whose runout period would end March 31st. This was an extension to make claims or to submit claims that occurred in 2019. You'll notice that it does not impact the date of service requirement. This was simply an extension to be able to make claims for those expenses that had already occurred. One of the things that we are doing administratively is one, making sure that we apply this to our systems, as obviously we are past the March 1st date. Many of our plans had already closed. So we're changing our system parameters so that administratively we can re-administer these claims that were denied correctly at the time that they happened. So now that we can reapply those, we'll be sending out more information and communicating directly with plan administrators through your account managers as well for any applications. And of course, any questions that you have, both your account manager and the compliance team will be glad to help with these.
Thanks, John. The change number 3 relates to the extension of Cobra deadlines. This extension applies during what the regulators have defined as an outbreak period. That outbreak period runs retroactively from March 1st, 2020 to 60 days after the end of the COVID-19 national emergency. So right now, we don't have a specific date for when that emergency will end. So that's a yet unknown date. In essence, the deadlines that you see here for qualified beneficiaries are told and start up again at the end of the outbreak period. We're going to be continue to send notices for Cobra qualified beneficiaries timely, even though there has been an extension for the issuance of notices by TPAs as well. We're going to continue to operate under the old Cobra rules as we know them and send those notices timely. But there are delayed deadlines for qualified beneficiaries, and we've got them noted here. So the deadline to notify the employer of the plan of a triggering event, the deadline to notify of a determination of disability, to submit a formal election to the plan, and then payments to make the first premium payment or any ongoing premium payments. All of these deadlines have been delayed until after the end of the outbreak period. So our current plan is to use the same notices that we have been using and to supplement those notices with communications to qualified beneficiaries about the changes. We're in the process of working on those communications and also in the process of making updates to our system to accommodate this extension. For some groups, this may have no impact on you. There may be some qualified beneficiaries who continue their behavior without regard to these extensions. But obviously for some groups, this may become an issue for you, and we are going to be prepared to help you deal with that and just try to minimize the impacts on employer groups that this may have. But again, more details to come along with training and additional information on how we're going to be handling this from an administrative perspective.
Along with the Cobra extension, one of the most effective extensions for our clients was also the HIPAA special enrollment. This has also been extended to the same degree that Laura mentioned for Cobra, which is the outbreak period. And so where this might affect your plan is, for example, with the birth of a child, somebody has the extension through the outbreak period to make that election for new coverage under there. We won't go into much detail about this because this is really something that would be particular to very small amount of cases, but we wanted to make notice of it because it is something that might affect your plan as well.
So the fifth change, and this was part of the guidance that was released yesterday, is an extension of time to incur claims. So this extends the eligible claim dates for health FSA. The specific guidance, there were two notices, as Jason mentioned at the beginning of our presentation. This particular notice is IRS Notice 2020-29. This notice applies to health FSAs and dependent care FSA plan years or grace periods ending 1/1 or later. So the guidance provides an extension of the time to actually incur claims after the end of the plan year or grace period until 12/31/20. So the standard rules that we've all known and love with respect to these plans were that an expense had to be incurred during the 12-month plan year. For health FSAs that have a grace period, that grace period typically provided 2.5 additional months after the end of the plan year to incur claims. So this IRS notice actually extends the period to incur claims until 12/31/20. So for some plans, this will have more of an impact than others. The extension will be longer for some plans than others. But one thing we wanted to note too is that this will also impact HSA eligibility for some participants. So if a participant has unused funds at the end of the plan year or grace period, the extension of time to incur claims in essence extends the HSA ineligibility. So that may be something to consider if you've got folks with potential HSA eligibility issues. As Jason mentioned, this guidance was released yesterday morning. We are currently researching the necessary system changes to accommodate the extension of time to incur claims. This is also going to require a plan amendment. Those plan amendments the requirement to amend is delayed, but we are working quickly to make the necessary updates to our SPDs to accommodate this extension.
Pulse check here. Laura's a pro, so she can talk about a major change like this, as if it's everyday news. We mentioned, this notice was released yesterday about 10 o'clock from the IRS, and this is landmark in the sense of, to Laura's point, as long as FSAs have been around, the plan year and date of service rule has been sacrosanct. So much so that when the carryover was first allowed for plans somewhere in the range of 2012 or 2013, it came as a major surprise to everyone, because it's an exception to the rule that the plan year is the plan year and dates of service must be within the plan year. So this is a big deal. It's going to help some participants for sure. So from the standpoint of participants having more time to spend their money and more of an opportunity to have and incur expenses after this COVID period subsides to the point that people can go back to the doctor and get out and spend their money. It is a good thing for them, but it's certainly a major adjustment in the way we think about FSAs. Even though, to Laura's point, this is a transitional rule, it will not apply forever. This is a 2020 transitional change, for COVID relief. Laura, one question, we've gotten a few questions FSA related. For example, one of them is, does the OTC change mean, we can go backwards as far as the beginning of the year to submit claims for OTC? And so whether it's looking backward or looking forward, can you confirm, is it correct that basically with the plan year being extended and the new OTC rule, that participants are going to be able to either go backwards pre-COVID shutdown period to submit expenses for OTCs, or, potentially, get reimbursed for OTCs or other expenses after the end of the plan year?
Yes, that's exactly right. The OTC change is effective January 1st, 2020. So it would apply to any expenses that were incurred from January 2020 going forward. And then this extension of the time to incur claims would give folks additional time after the end of the plan year or grace period to incur expenses or to incur OTC expenses. So they could use those funds either way. And that's a great point about assisting participants. I know when the COVID emergency first started, we received lots of questions from our partners and from participants for folks who had either appointments scheduled that were canceled or procedures scheduled that were canceled that they had included in the calculation for their FSA election. So again, while this it is going to provide some administrative gymnastics and maybe some gymnastics for employers, it really will help participants who had planned on having some significant FSA expenses and had those appointments or procedures canceled.
Another related question, does the new Notice 2020-29, the new available extension, does it apply only to plans that have the grace period, or does it apply to all health FSA plans?
It applies to all health FSA and dependent care FSA plans. So it's going to extend the extension of time to incur claims for those plans that don't have a grace period, so for health FSAs that don't have a grace period. In addition, it is also going to extend the time to incur claims for health FSA plans that do have a grace period. So the standard rules for grace period was that the grace period was 2.5 months after the end of the plan year that a participant could incur additional claims or additional expenses. And this Notice 2020-29 is going to extend that grace period until 12/31/20. So it is both. It is an extension for plans that don't have a grace period and extension for plans that do have a grace period.
Yeah, well said. And one thing we started doing yesterday and processing the guidance, and our admin team is working on today, is effectively a plan grid where we're looking at every plan year, both those that have recently ended and that have already ended in 2020, all the way through the ones that will end this time next year, and looking at every single plan year, so based on when the plan started, when it ends, what applies? Does the extension apply? Does that plan have carryover? So, it depends on the plan, but to Laura's point, any health FSA or dependent care, I'm glad you mentioned that, can take advantage of this extension. Thanks, Laura.
Along with that notice, up on the screen here, this is an issue that a lot of clients have asked us about with so many changes as a result of the virus and offices being closed, that they had participants who needed or wanted to make election changes. As part of IRS Notice 2020-29, they have made allowances for election changes to health FSAs, which also includes limited FSAs, dependent care assistant plans, as well as group health plans. And so this is a big relief that a lot of clients had asked us about for their participants. As Laura has mentioned, of course, this requires plan amendment, but again, grace has been given to do that. But what this allows is for a client to permit election changes from their participants to reflect needs that they may have or needs that have changed under the virus. A lot of folks particularly were asking about dependent care, but this actually made it a little more broad allowance for group health plans as well as FSAs. A couple of things to note, and again, this is where we will be glad to help work on this. This, along with most of the other changes, are permissible for clients, but are not required. So you can allow these changes to happen. One important thing to note about mid-year changes is this is not an unlimited amount of changes. So you as a client can permit the change to happen one time as a reflection of changing needs, but it's not something that you have to allow somebody to jump in and out of their election at will, or even like with an HSA where elections can be changed month to month as HSA needs change. This is not an unlimited discarding of the rules, but it's trying to provide flexibility for folks whose needs may have significantly changed, and for clients and employers that really want to assist their employees with adjusting for those needs. Again, this is applicable through December 31st of 2020, and so we are working on making those plan amendment changes. But if you have questions with this or any other thing, please feel free to email or send that in to us. And we're working with our administrative teams to be able to permit this and to apply this in the system. But since it came out just yesterday, we have more details coming on that later this month.
Yeah, thanks, John. And just a quick clarification there, as John said, the plan administrator remains the referee for status changes. So this allows the plan to recognize and implement additional status changes that would not otherwise be allowed. So the plan is still in control of status changes. That's the way we help administer plans, not only in accordance to IRS rules, but if anything's going to be beyond the IRS rules, that status change is either going to be denied or, in this case, reconsidered as a result of the new rule. That let's distinguish that from the prior change, the extension of applicable deadlines. While technically permissible, those are going to apply to health FSA plans, in order to assist participants. So we will continue to treat status changes the way we always do, which is when the employer brings an election change to us, we are going to administer the plan according to the election change allowed by the employer, unless there's a reason not to, and to dive into that deeper with the employer. But we are certainly still deferring to the employer on which status changes are allowed. This simply allows the employer to approve more changes.
And Jason, just as an additional note on those status changes, one of the things that the guidance refers to, and it's a good time to remind employers, these need to apply. If you're going to apply them, they need to apply across the board, not just to your executives or to your highly compensated folks. Change number 7, most of the changes that we have talked about so far have been changes that are limited in their duration. This is actually a change that is going to stay around for carryovers. And we had sort of an inkling that this might happen. If you think back to 2019, going back even further than where we were for the OTC in March, President Trump issued an executive order back in the summer of 2019 that suggested that he wanted this carryover to be increased. We hadn't seen anything until yesterday, and we received IRS notice 2020-33. This notice increases the carryover max for health FSA plans that have a carryover. Again, as a reminder, you can have a grace period or a carryover. You can't have both. Since the beginning of carryover time, the carryover maximum amount has been $500. So this would allow a participant with unused funds at the end of the plan year to carry over those funds into the subsequent plan year. And as I said, that limit has, since this was originally enacted, has been $500. So beginning for plan years beginning January 1st, 2020 or later, the carryover is now indexed as 20% of the IRS annual maximum. So the 2019 carryover maximum remains $500, but for 2020 health FSA plans with a carryover, the carryover max will increase to $550. So it's an additional $50 that a participant could carry over from the 2020 plan year into the 2021 plan year. So based on the way that the IRS has indexed this, in essence, what that means is for every $50 increase in the FSA annual maximum, that's going to equate to a $10 increase in the carryover. So for example, assuming in 2021 that the IRS continues with its history of increasing the FSA max by $50, that would increase the maximum for 2021 to $2,800. Then the 2021 carryover would increase to $560. Again, we are working on SPD updates to accommodate this change. We anticipate that the language will be similar to the language that we use currently for the ACA FSA maximum language change. Those of you that are FSA clients, we refer to the annual maximum. Since the carryover is indexed, our goal would be to include language so as not to necessitate annual document changes if there are no other plan changes. So it would be a similar language to our current language for the FSA maximum. More information to come on that, but this carryover is going to stay around, and it will continue to increase from year to year.
A couple of other quick words about HSA bank accounts in case you missed it. These were included in the CARES Act back in March, so these are not brand new changes. Just want to reiterate these items in case you assist and facilitate employees with HSA bank accounts, which of course are owned by them and are not, group health plans the same way that health FSAs, HRAs, or the group health insurance plan would be. The first HSA change announced was that an account holder can fund the 2019 account up to the 2019 maximums, either for self-only or family coverage, with contributions all the way to 7/15 of this year. So the income tax deadline was extended to 7/15, which extended the HSA contribution deadline for 2019. So we're still in the window where someone can fund 2019 and 2020. After 7/15, individuals will only be funding up to the 2020 maximums. Obviously, it's just one account, but the annual contribution amounts matter, and that's something that has to be verified in the tax return process. Also, for HSA eligibility purposes, the health insurance plan, specifically the high deductible health plan, can provide no cost or copay COVID-19 testing, some forms of COVID-19 treatment or assessment, and also telemedicine services, not only for COVID-19, but also other doctor's visits, specialist visits, etc., the telemedicine option can be provided for no cost or a copay by the high deductible health plan, and the individual to still be HSA eligible. Those things would not be true in a normal scenario outside of this transitional relief, which is, as some of the other items are, transitional relief that is not expected to apply past 2020, but those are the current rules. And we would also like to, before we wrap it up and get to any remaining questions, just give you a quick reminder of mid-year deadlines. One of our upcoming compliance updates will remind you of the PCOR fees, which are due for self-funded health plans by July 31. That deadline may be extended, but it hasn't been as of now. So the PCOR fee applies to self-funded major medical plans and also HRAs. Employers that have a self-funded HRA and a self-funded health plan only have to file one PCOR fee. But anyway, PCOR is something we assist HRA clients with on an annual basis, preparing IRS Form 720. That's something we are working on now, and we'll have emails going out to groups sometime in early June. More to come on that. And just a reminder that Form 5500s for health and welfare plans that have 100 or more employee participants in one or more ERISA benefits are due 7 months after the end of the plan year. So there have been some minor Form 5500 extensions so far that really don't matter. The calendar year plans are not delayed, so we are all systems go as far as getting all calendar year plans filed by the standard deadline. And our plan is to file as many as we can. So even if the deadline is extended, our employer clients for 5500s get everything filed so we can move on to other things. But the calendar year deadline is 7/31. If you're a Form 5500 filer and not working with us, we'll be happy to assist you with that. Laura, John, thank you. There have been a number of written questions submitted. I think we've gotten to 2/3 of them, but not all of them yet. If you have submitted a question we have not answered yet, feel free to hang around for a few minutes and we'll get to that. You're also welcome to email that question to compliance@probenefits.com. We appreciate your time today. Again, our team is here to assist and serve you, and if we can do that for any administrative or compliance service, we'll be happy to. Again, we will provide a copy of the slides along with a link to the recording in case helpful to you or any teammate. So again, thank you for your time today. If you're wrapping it up now, take care and best wishes. If you are hanging around to submit a question or wait on an answer to a question, we'll get to those here in the next few minutes. Thanks, guys.